Well, friends, here we are on the cusp of closing arguments in Donald Trump's first criminal trial, his first of 4. And I have a feeling Donald Trump's defense attorney is about to get schooled by the prosecutor. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, if you've been following the reporting about Donald Trump's first criminal trial, you saw a professional, convincing, compelling presentation of the evidence by the prosecutors and a messy, uneven, scattershot approach by Donald Trump's criminal defense attorneys. So I just wrote a piece for MSNBC that is something of a preview of the upcoming closing arguments, and with your kind permission, I'd like to read it to you. It's pretty short, and then I want to turn to why all indicators are that the prosecution's closing argument is going to be strong, and the defense attorney's closing argument is likely to suffer from some serious problems that I've seen defense attorneys encounter in other criminal cases that I prosecuted as a former career prosecutor. But again, with your kind indulgence, I'd like to read the short piece that I just wrote for MSNBC. It's titled, "The Hidden Trap for Trump's Defense Team in Michael Cohen's Testimony." Donald Trump's fate will soon be in the hands of 12 citizens, a jury of his peers. The jurors will be tasked with deciding if the prosecutors proved Trump's guilt beyond a reasonable doubt. Central to that decision will be their assessment of the credibility of star witness Michael Cohen, Trump's former lawyer and self-described fixer. By his own admission at trial, Cohen has lied, cheated, and stolen, including from the Trump Organization. That may seem like a problem for the prosecution, yet in my experience, it's anything but. The very fact that Cohen himself admitted to his prior lies and criminal activity may very well lead the jury to credit his testimony and use it to convict Trump. In my 30 years as a prosecutor, I dealt with countless cooperating witnesses, CWs for short. That term most precisely describes defendants who plead guilty to their crimes and enter into a cooperation agreement with prosecutors to testify fully, truthfully, and accurately about the crimes of others. In exchange, the cooperating witness receives a reduced plea or a more lenient sentence. As part of the deal, the cooperating witness must also admit to and be prepared to testify about the crimes they themselves committed. This standard practice is vital to building the witness's credibility. You can't expect a jury to believe the testimony about the crimes of others if the cooperating witness is unable or unwilling to fess up to his own crimes. Cohen is what I'd call a de facto cooperating witness. Why? Well, he pleaded guilty to his crimes and agreed to testify against Trump, but without entering into a formal cooperation agreement with prosecutors. Cohen may be a deeply flawed individual and someone who was all too willing to commit crimes for his boss and for his own financial gain. But he's also an entirely typical cooperating witness, someone perfectly positioned to expose to the jury the crimes of the bigger criminal fish in the corrupt scheme. Of course, in this instance, that would be Donald Trump. Now, a conspiracy is a secret agreement between two or more people to commit crimes. By their very nature, these criminal agreements are designed to shield the conspiracy from public view. This is why prosecutors work mightily to corral an insider, a co-conspirator, and develop that person as a cooperating witness who can authoritatively inform jurors about what was going on inside the conspiracy. But as former criminals, cooperating witnesses generally have plenty of baggage, which brings us back to Michael Cohen. In many ways, Cohen was a nearly perfect cooperating witness. He was in direct communication with the bigger criminal fish. He even had a covert audio recording that helped prove Trump was involved in the corrupt scheme to hide damaging information for political advantage. Cohen testified that he committed crimes at the direction of Trump and, importantly, for the benefit of Trump. The fact that the crimes inarguably inured to Trump's benefit, he, Trump, not Cohen, was the one running for and ultimately winning elected office, that fact that the crimes inured to Trump's benefit will not be lost on the jury. Indeed, though Cohen may have hoped to benefit in the future from helping Trump, these crimes arguably worked to the immediate detriment of Cohen. He had to take out a home equity line of credit just to muster the $130,000 payment to Stormy Daniels. Cohen spent more than 20 hours on the witness stand, reportedly without becoming angry, belligerent, or losing his cool. The same cannot be said of the only defense witness of consequence, Robert Costello. Though Costello himself is a lawyer, he was beyond belligerent, and Judge Juan Merchan at one point cleared the courtroom to admonish Costello for his, quote, contemptuous behavior. The jury undoubtedly took note of the dramatic contrast between Cohen's performance and Costello's. Now, 2 points in Cohen's testimony were touted in the media as deeply damaging to his, Cohen's, credibility. The fact that he may have mixed up the date of the precise phone call in which he told Trump he had made the hush money payment, and the fact that Cohen stole $30,000 from the Trump Organization. This old prosecutor saw those 2 bits of Cohen's testimony quite differently. Were I prosecuting the case, I would address the phone call in my rebuttal argument, not my initial closing argument. My rebuttal argument after the defense undoubtedly addressed it in their closing argument. Then I would have asked the jurors if they had precise recall of the date and time of phone conversations from 8 years ago. The question answers itself. So whether Cohen told Trump that he made the hush money payment in a call on a Wednesday or a Thursday is immaterial. More importantly, does anyone believe Trump would have begun writing Cohen a series of $35,000 checks from his personal bank account if Cohen had not told Trump the payment was made? Please. The second revelation, that Cohen stole $30,000 from Trump, is a perceived weakness in the evidence that I would actually turn into a strength. In closing arguments, defense attorneys frequently fall into a trap of urging the jury to disbelieve a cooperating witness's testimony when that testimony incriminates their client, incriminates the defendant, but they urge the jurors to believe the same testimony when it incriminates the witness. The defense attorney likely will tell the jury, quote, "You can't credit Cohen's testimony because he's a thief, having stolen from the very person he, as an attorney, was supposed to zealously represent." That argument carries some superficial appeal, but I would rebut it this way. Ladies and gentlemen, who is it that proved to you that Michael Cohen stole $30,000 from the Trump Organization? It was Michael Cohen himself in his sworn testimony. And here's the important part. Cohen's testimony about his theft was uncorroborated. No other witness came in here and testified about it. There was no audio recording exposing it. There were no business records confirming it. So the defense is telling you to credit Michael Cohen's uncorroborated testimony when he tells you he stole $30,000 from Trump. Yet, when Cohen's testimony is corroborated by other witnesses, by audio recordings, by phone records, by business ledger entries, and by Trump-signed checks, falsely purporting to be reimbursement for legal services, when Cohen is corroborated 8 ways to Sunday, the defense urges you to disbelieve his testimony. Let's be clear, ladies and gentlemen. The defense wants you to credit Cohen's uncorroborated account of his own misconduct, but disbelieve Cohen's fully corroborated testimony if it hurts Donald Trump. Ladies and gentlemen, the defense has just invited you to fall for the bait and switch. But we know you won't. I would finish by reminding the jury that the prosecution didn't choose Cohen as a witness. Trump chose him as a witness when he enlisted him in his corrupt scheme to pay hush money and falsify business records to gain unfair advantage in a presidential election. Cohen may very well have lied, cheated, and stolen, but he also testified about what he did as Trump's co-conspirator, his partner in crime. And soon, a jury will get to decide if that testimony, together with the significant corroborating evidence, is enough to prove Trump's guilt beyond a reasonable doubt. Okay, friends, first of all, thank you for letting me read that. It's a lot easier than just trying to remember it off the top of my head. But now I want to turn to a couple of problems, serious problems, that Donald Trump's lead defense attorney, Todd Blanche, will have in his closing argument. Donald Trump never gives an inch. He never concedes anything. He never admits he's been wrong. He never apologizes. He never gives an inch, right? We've heard him say this. He's a fighter. I fight, I fight, I fight. I never admit I've done anything wrong. That may be a good public relations approach to life. Maybe it benefits him in the court of public opinion. Maybe it doesn't. I don't think it does. But what I know is never conceding what the evidence proves in a court of law in the setting of a criminal trial can be fatal to a defense. What do I mean by that? Donald Trump's lawyer gave his opening statement and said Donald Trump never had an encounter with Stormy Daniels, never had sex with that woman. That was obviously what Donald Trump instructed his defense attorney to tell the jury. And once you absorb all of the evidence, that was clearly a lie, right? Anybody who's familiar with the 30 to 40,000 documented lies, I believe by the Washington Post, that Donald Trump told even just during his presidency, knows Donald Trump is a stone-cold liar and not a very good one, not a very convincing one. I mean, he contradicts himself over time. And anybody who saw Stormy Daniels give interviews about the encounter or listened to the reporting, paid attention to the reporting coming out of the New York courtroom during the trial, it's pretty obvious they had an encounter. So if the jurors conclude, and they will, that Donald Trump's attorney stood up and lied to them in opening statement about that encounter, which really didn't matter. He didn't have to take that position, but you already know that Donald Trump forced him to take that decision, and that was a strategic and tactical mistake. If the jurors decide, well, they're lying about that, that will color their perception of every other defense claim that the defense made during the course of the trial and that the defense will make during the course of the closing argument. So here is the box in which the defense now finds itself. They're going to have to do something in closing arguments that we refer to as arguing in the alternative. And I'm going to give you an example of how Trump's attorney may have to argue in the alternative in Trump's closing argument. But let me start with a more relatable example, one that I've seen many times as a former prosecutor, of a defense attorney arguing in the alternative. Let's use a readily relatable example, a murder case. I have seen defense attorneys in murder cases I tried stand up and argue in closing to the jury, ladies and gentlemen, my client did not kill the victim. But if he did it in self-defense. Those kind of arguments in the alternative are not well received by jurors, even if there's a little bit of a question regarding the identity of the killer and a little bit of a question regarding whoever the killer is. That person might have acted in self-defense. The defense will argue in the alternative, but those two arguments cancel each other out because the jurors feel like you're trying to pull the wool over our eyes. How can you argue to us, he didn't do it, but if he did it in self-defense? We don't believe either of those two claims. They negate one another. And in a common sense view of the evidence, they can negate one another. But arguing in the alternative is something defense attorneys do, all the time in different cases in different contexts. Here's how Donald Trump's attorneys are, in essence, going to have to argue in the alternative, particularly because Donald Trump will not allow them to give an inch. They're going to present an argument that in substance, they'll try to gussy it up and hide what they're really doing, but in substance, it will be an argument along these lines. If you're Donald Trump will contend, I never had an encounter with Stormy Daniels. But if I did, there were no hush money payments. But if there were, I didn't know anything about the hush money payments. But if I did, I didn't falsify any business records to cover up the hush money payments. But if I did, it was all to protect Melania's feelings. So maybe it's just a misdemeanor and not a felony because it violated campaign finance and election laws. That kind of arguing in the alternative, which I predict you're going to see some of or read the reporting about some of that going on in the defense attorney's closing argument, that rarely plays well with a jury because they feel like they're being duped, like there's a little bait and switch going on, and there is. And that's why I think because Donald Trump's defense attorney opened on he never had an encounter, the minute the jury believes they've been lied to, and the evidence proves that they have been lied to in that regard, they're not going to be receptive to all these other secondary and tertiary arguments that the defense tries to offer them to help Donald Trump weasel out of the crimes he committed. The crimes the evidence proved he committed. So I'm looking forward to reading the accounts of closing arguments. I sure as heck wish there were cameras in the courtroom. It would be better for everyone. It would be better for the interests of justice. But we'll have to settle on reading the real-time reporting coming out of the courtroom. And then after closing arguments, I will come back and we'll talk again in the next Justice Matters video about how those closing arguments fared, how they played out. And I have a feeling we may be in the home stretch. We may be in the home stretch heading toward accountability for Donald Trump for at least some of the crimes, just some of the crimes he committed. Because justice matters. We're getting there, friends. We're getting there. As always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.